Is Rafik with us?
Well, he's connected online.
Yes, he is.
Okay.
Good morning, Your Lordship.
Okay, Rafik, how are you?
I'm very fine, sir. Good, sir.
Thank you. So which one are we taking? John Ogazi?
Yes, sir. Mr. Bimbo,
Okay.
your wig.
Oh, you know this virtual thing. I totally forgot. I'm sorry, my lord.
It's all right. So we are adopting that of Ogazi for the remaining ones, or we'll take them one by one.
Well, my lord, what I will suggest,
yes,
and subject to your lordship's, there was one of the cases that was used as a test case where parties, yes, and we now made reference to it in other cases.
Okay.
Mr. Rafik, I'm sure you know what I'm talking about.
Okay, that's
so which one is that one? Is it John Ogazi? We've been using John Ogazi as the test case.
Test case, yes.
Yes, ma'am. So we can simply use that. Then we now just adopt all of them collectively, but it can be adopted in that particular case.
Yes, because the evidence and everything is in John Ogazi. So we use John Ogazi. Yes.
Resume today, February 4th day of April 2025, before His Lordship, Honorable Justice P.I. Hamman. Suit number NICR/PHC/88/2021. Case between John Ogaji and Pipe Quotas Nigeria Limited. Below parties are absent.
Respectfully, my noble lord, Bimbo Atilola.
Yes, Bimbo.
For the claimants. Bimbo Atilola for the claimants.
Yes, Rafik.
Yes. Respectfully, Rafik Anam. With me is Abigail Jua. Together, we humbly appear for the defendants.
Yes, Rafik.
Okay. My lord, the matter is slated for adoption of final written addresses, and we are ready to proceed with the kind leave of the court.
Yes, go ahead.
Yes, but before we adopt, there is a slight amendment that to make in paragraph 2.1 of our reply on points of law. Just an
2.1 of the reply.
Reply, yes, my lord.
So what is the issue with
it treats that the claimant responds to the new issues raised in the defendant's written address. But it should read that the defendant is the defendant responds to the claimant to the new issues raised in the claimant's written address. So that's the
is that material? Can you respond to issues in your own address? Any person that looks at it will know that yes.
As the copplices.
Yes. He cannot respond to his own written address. So
address.
I don't think that that is even substantial that will require any application.
As the court pleases. So we can proceed, my lord.
Yes.
Yeah. So, my lord, the defendant has filed a final written address dated the 2nd day of October 2024. And filed on the same day, on the 8th day of October 2024. Dated the 2nd October 2024 and filed on 8th October 2024.
Dated
the 2nd of October 2024 and filed on the 8th day of October 2024.
Yes.
Upon receipt of the claimant's final written address, the defendant also filed a reply on points of law dated the 13th day of February 2025. But filed on the 14th day of February 2025.
Filed on the 14th of
14th day of February 2025.
Yes.
The defendant adopts its argument in its final written address and its reply on points of law as its argument in support of its case. And we humbly urge this honorable court to dismiss the claimant's case in its entirety with substantial cost. But before we sign up, my lord, we need to adumbrate a bit. Just a few minutes.
Hold on.
Yes, go ahead.
Yeah, though our arguments have been fully captured in our addresses, but there are just some silent points I need to point out for the court's notification. Yes. So I'm going to refer to all the matters together because these points affect all of them since we are adopting. So the first point that I want to point out to the honorable court is that the subject matter before the court or the parties' cases before the court are actually different. They are not the same. Though they are created or they are argued in a way or pleaded in a way that they seem the same on the pleadings. But in character, they are different.
Yes.
First of all, all the claims of the plaintiff or the claimants are based on redundancy. All of them are based on redundancy. But from the evidence before the court would see that some of the claimants' cases, their terminations were, the termination of the employment were not based on redundancy, but on termination by efflution of time of their employment contracts.
Yes.
So they are claiming redundancy benefits, but they were not declared redundant. Their positions were not declared redundant. The evidence, we've pointed all the evidence out before for the court's notice in our addresses. For clarity purpose, I'd like to refer or specify those claims, those suits, so that the court will take note of them. The first one is NIC and PAT.
I think Mr. Rafik,
Yes, my lord.
The cases have not been consolidated. We are only taking this one as a test case, so that we,
yes.
But in writing the judgment, I will consider each of them, each case on its individual
merits.
It's not as if I'm just going to use the written submission in this very one.
Okay, at the court pleases, but at least
Yes.
we've brought that to the fore, to notice of the court that
yes.
these matters
yes.
are in substance, they're actually different. They're not the same. Then the second point we need to note, or we intend to note, is that the claimants in some of their cases did not tender their employment contract before this court.
Yes.
The employment contracts are not before the courts. And the law is very clear that the employment contract is the bedrock of an employment dispute. And it is what gives the court jurisdiction to even look at the disputes. And we cited authorities on that.
Yes. I'm sure you have all this in your written submissions.
Exactly, my lord.
Yes.
Then also our arguments that I also want to emphasize is that the failure to supply the employment contract, to tender this employment contract, if the court looks at the pleadings clearly, the court would see that it is an intentional act to withhold evidence from the court because it will work against the claimant's cases. That is why they withheld those employment contracts. In some of them, we were able to provide it, but in about 6 of them, we did not provide the employment contract for them because it's their responsibility to do so. Therefore, our arguments are already in our final written addresses. Then the third point that I want to point out is on the issue of the validity of the witness statement on oath, because this goes to even the foundation of our defense before the courts. We've advanced arguments to show, my lord, that the validity of the witness, though the witness stated during cross-examination that he signed the witness statement on oath in his lawyer's office. We attempted to re-examine on that point, but unfortunately, the court upheld the claimant's objection to our attempt to re-examine. But we've advanced arguments to show that evidence that he got, or that he had signed the witness statement on oath in his lawyer's office, was elicited during cross-examination. That is very important. It was elicited during cross-examination. And the claimant the party did not join issue on that point, on where the witness statement on oath was signed. And the law is clear that evidence that is not supported by pleadings go to no issue.
Yes.
It is evident that elicited during cross-examination, but there is no part of the party's pleading that supports that evidence. And the authorities that were supplied to the court that show that such an evidence cannot be relied on in termination of a matter.
You have this in your written submission as well.
Yes, my lord. And we supplied the latest authority of this honorable court, of the National Industrial Court, Justice Oji.
Yes.
We supplied to the, in fact, we supplied the CTC attached to our reply in point of law. So that we're urging the court to discontinue that evidence and to rely on the DW1, the defendant's witness statement or note, in the termination of this suit.
Yes.
Yes. So, my lord, I think that's all that I want to put forward in adumbration. But finally, we are also arguing that in the unlikely events, my lord, that the court says that there is no evidence, invalidates the witness statement on oath. That on the claimant's case itself, be evident before the court itself, let's assume there's even no defense for the defendant, that the claimant cannot succeed on its own evidence. And the law is clear that when a party is seeking declaratory reliefs, even on the admission of the defendant, the party is still required to prove its entitlement to that relief by credible and cogent evidence. So the absence of a defense from the defendant still does not entitle automatically the claimants to a judgment. They must still prove their case on evidence, credible evidence before the court. And we are saying that they have not supplied this evidence before the court. Because even their evidence supports, especially the subpoenaed documents that were brought before the court, supports the defendant's case that the issue of ex gratia, the issue of payment of ex gratia by defendant to its former employees is contractual. And we pointed out the parts of the exhibits on the supplemental witnesses that show that these things are contract. There are provisions in those exhibits that showed a contract between the employees and the defendants. And this is what is different from the claimant's cases in this, because there is no contracts at all. But all the other parties' cases that they've tried to rely on show that there were contracts. So the issue of discrimination does not arise in any way.
I'll look at the processes. Yes.
At the court pleases. So finally, my lord, based on our adoption, our total arguments in our written addresses, we ask the court humbly to dismiss the claimant's cases. May it please the court.
Now your submission on the issue of adopting this one as the test case, so that I'll have you on record.
Yes, my lord. My lord, we humbly urge this honorable court to apply or adopt our submissions in this suit number NIC and PHC 88/2021 as our submission in the other sister cases.
All right, thank you. Yes, Bimbo.
Thank you, my noble lord. On behalf of the claimant, we filed a final written address dated the 2nd day of December 2024.
Dated when?
2nd day of December 2024, December 2, 2024.
Yes.
And we seek to adopt same as our final.
No, when was it filed? You can't just rely on the data.
It was filed on December.
Yes, when was it filed? That is
filed on December 27th. Yes. Dated December 2nd, filed December 27th, 2024. And we seek to rely on same as our final written address in this matter.
Yes, go ahead.
My noble lord, we also seek to adopt argument canvassed in this final address for the other sister consolidated suits. For the other sister consolidated suits. However, this notwithstanding,
yes.
However, this notwithstanding, where issues are slightly different in any material way, we specifically address them in the individual final written addresses.
Yes, I will look at the cases. I will look at the cases individually. Since you file written addresses in, yes.
So we adopt all of them in their respective suit number as if same were adopted seriatim.
Yes.
My noble Lord, just a very short one. I will take far less time than my colleague did in the very short adjudication. The first issue on the question of letter of employment. My learned friend has argued that in some of the cases that we did not tender letter of employment and that they assisted us to tender some of them in some of the cases and that we deliberately withheld some. My Lord, the starting point is that employment relationship can be established not only in writing. It is tried that employment relationship can also be established orally, even by conduct of the parties. Yes. So, what gives this court jurisdiction is not letter of employment, but existence of employment relationship. So my learned friend misconceived the law when he thought that it is employment letter that gave jurisdiction to this court. It is not employment letter, but employment relationship. So I can come to this court if I can otherwise show there is employment relationship, but for some reason, the letter of employment maybe is missing, or I don't even have any. So it is fact of employment relationship that gives jurisdiction to the court. And more importantly, my Lord, my Lord, parties agree in pleadings that the claimants were employees of the defendant. Parties agreed in pleadings. So that fact was admitted. It is not an issue at all.
Yes.
The issue before the court is whether they were entitled to more money. So it's not whether there was employment relationship. And finally, on this issue, and that is the reason why employment letter will not even be very important. Finally, on this issue,
yes,
the claimant submitted that the redundancy pay and the ex gratia that they are asking for, they submitted that it is not by virtue of any contract of, it's not by virtue of any express provision in their contract of employment. The claim they asked for, the ex gratia they are asking for, or indeed any financial claim they are asking for, it is not by express provision in their respective contract of employment.
Yes.
They said it is an implied term. So they are saying it's not even contained in our letter, but it's an implied term. And that has become the culture and customary practice of the company to pay it. So this employment letter theory is superfluous in this case because the claimants are not relying on the employment letter to prove what they are entitled to. My Lord, on the issue of witness statements, my learned friend again misconstrued the law when he stated that before anybody can rely on evidence or whatever is elicited during cross-examination that the issue must have been pleaded, or the party need to go and amend his pleadings to capture it. My noble lord, the first elementary law is that pleadings is different from evidence. We plead facts.
Yes.
We do not plead evidence. So admissibility, including technical issue of evidence. Admissibility, yes, including technical issue of evidence, is governed by law. Admissibility and technical issue of evidence, such as validity of witness statement, and technical issue of evidence, such as validity of witness statement,
yes,
is governed by law, not facts,
yeah,
not, I mean, it is ridiculous that my colleague imagined that I will have known in advance that the witness statement, that the witness signed the witness statement or will sign the witness statement in his lawyer's chambers. And these are technical issues of evidence.
Yes.
It is also important that by agreement of the parties in court, we both agree that all issues relating to admissibility and technical issues of evidence will be addressed in our final written address. That was the agreement of both parties in open court.
Which I am sure you have done.
Absolutely, my lord.
It's all right. So, I'll look at the processes.
Sorry, my lord.
Let me finish,
sorry
please.
You finish. Sorry, my lord. I'll need to respond to that particular when you finish.
No, let me finish now, yes, Mr. Rafik. I have to finish so that.
Yes.
No problem.
I have to finish.
Bimbo, begin to round up now.
You are finally, my lord.
Yes.
Finally, my lord. The same claimant, the same defendant counsel who is making this argument,
yes,
relied extensively on various evidences generated during cross-examination of all the claimant's witnesses.
Yes.
Made extensive. So if his argument is correct, then that means your lordship too will not look at all the, with jettison all the references made to issues of facts elicited during cross-examination.
Yes.
And on this point, my lord, yes, I rely on the various decisions of the court which we have canvassed in this final address, including the decision of your lordship on a similar, yes, point of law. So,
yes,
based on that, my lord, and finally this time, based on that, the claimant's case before this court, the claimant's pleading before this court, we operate as undefended.
Yes.
And therefore, the claimant only need to satisfy minimum proof. To get only need to satisfy minimum proof to get judgment.
Yes.
I would also like to refer my lord to the fact that we also have alternative reliefs, which we have equally canvassed arguments in respect of same. Thank you, my noble Lord. I do not know the principle of law that allows my learned friend to re-argue in his final written addresses. He adopted his final written addresses, including the reply, and he argued them. So I do not know where lies this further right of reply my very good learned friend wants to explain. But I leave it to my Lord. I leave it to my Lord.
The cases are for adoption of final arguments, and you've adopted your processes.
Yes, my Lord. I'm not replying to just for clarification. I don't want to provide a clarification. Learned Counsel said the parties agreed in open courts that all issues
I will be guided by the graphic. Whatever you say on this will be immaterial. I will be guided by my record. The course record is there. Yes, so there is nothing you will say that will change what is on record.
No, I just want to say that our agreement was on admissibility of documents. That our objection.
Don't worry.
Okay.
There is nothing he has said that will even change what is on record. I will be guided by the record of the court.
As the court, please.
As the court, please.
As the court, please.
Yes, sir. The parties having adopted their final written addresses in this suit, the judgment is hereby reserved and date shall be communicated to the parties. And by the agreement of both learned counsel, this ruling shall apply or abide the sister cases with suit numbers NICN/PHC/90/89 2021, PHC/90 2021, PHC/91 2021, PHC/92 2021, PHC/93 2021, PHC/94 2021, PHC/95 2021, and PHC/96 2021, listed as numbers 2 to 9 on today's cost list.
As the purposes.
All right.
My Lord,
Thank
I'm
you.
most grateful for the time God has given to us.
Yes,
since 2021 to date.
Yes, sir.
We are almost coming to
Chief Rafi, you really stressed me. 2021.
All right.
2025.
Thank you. Have a nice weekend. Bye-bye.
Thank you, my noble Lord.
Thank you.
Thank you, my noble Lord.